Hello, welcome to episode 51. Wow, it's hard to believe that it's been that long. This is part three of our divorce series, and today we're going to talk about what happens if you're actually served with a divorce complaint, and what you have to do and what to expect, as opposed to being the plaintiff, you are the defendant. And so that is what we are going to talk about today, and then we're going to talk about um, a little bit about custody and the best interest factors. Tomorrow we'll finish up the best interest factors and we will talk about parenting time. And then on Friday, we will talk about the judgment of divorce, actually, what's in a judgment, what to expect, how to keep the end in mind when you are beginning the process, and things like that. So, to start today, there are two parties in a divorce proceeding. There is, good afternoon, Brenda. I guess it's morning for you. Um, she just sent me a big hello in the comments. I love that. So today we're going to start by talking about who are the parties. The parties are the plaintiff and the defendant. The plaintiff is the person who files. The defendant is the person who responds. The After the defendant is served, and as we talked about yesterday, that can look like a whole bunch of different things. Then the next thing that happens is that there has to be an answer filed to the complaint. Um, the complaint will have multiple paragraphs. Some of them are required to be there by law, and some of them are just actual averments that are the reasons why either the parents need to be divorced, or the kids need to be with one parent over the other. Could be about financial status. It could be anything. Other paragraphs. So the first thing that we do if someone's already been served is we have to find out what's most important to them. What are their goals? What do they want? Um, you know, we have several different kinds of clients in the divorce world. We have the client who's like, "Oh my God, I can't get out of this marriage fast enough. I already have a girlfriend. I already have a boyfriend. You know, give them everything they want. Just get me out." We have the people who are all those things, but are give them everything I want. I just want my kids. Um, or the people who are like, I just want that couch. It can be that petty, but whatever they want. They have to know what they want. That is half the battle. Then, and then we have them look and focus at the future. Um, Oh, I forgot the most important kind of client that we have. Unfortunately, sometimes because Michigan is a no-fault divorce state, we also have the client who doesn't want to be divorced. And those are emotionally challenging, but we explain to them that, in Michigan, it's a no-fault state, and if one person wants to be divorced, then they can get divorced. And so we always give those people referrals to counseling and some suggestions of discussions that they can have with their spouse for how to untie the knot peacefully, or if there is a possibility of reconciliation. Certainly, I would say that most divorce complaints are at least drafted and those attorneys are hired when emotions are high and anger is existent, and um, sometimes that needs to be toned down for a reality check, and then people can figure out what they really do want. So, um, so basically, at the initial interview, if you've already been served, we're going to talk about what you want, what your goals are. Basically make you familiar with the process. I always um, recommend to people who don't want to be divorced and are now going to be divorced that they read On Death and Dying, which is a grief book, because that's really what that's the feelings and emotions that people go through. In that situation, I or an attorney, not just me, we file an appearance. That means that we represent the defendant, and we file an answer. The answer has to be um, filed uh, within 21 days if the person lives in Michigan, or 28 days if they live outside of Michigan from the date of service. Then in our answer, we would correct anything that we believe is inaccurate, and we would deny anything we believe is untrue, and we would admit the things that are true. We would also look at that point, let's say that the original complaint says that that parent is the uh, best and only fit and proper parent for the children. Then we would want to file a counter complaint saying either that the defendant is the fit and proper parent, or that both of them are the fit and proper parent, depending on what that individual's goals were. So a counterclaim can be just a counter complaint where we file our own complaint, or it can be just a counterclaim at the end of our answer. Other motions that we may want to consider filing at that point, depending on who the client is, we may need to file a motion for immediate spousal support. We may need to file a motion for possession of the marital home. We may need to file a motion for to get personal belongings out of the marital home. We may need to file a motion for a restraining order on the assets so that no one can deplete or destroy or sell or give away or donate, like we talked about yesterday. And so all of those things are still in our wheelhouse as the defendant. We also may need to object to any ex parte orders that have been entered. We have a right to object to them within 14 days of the day that they are entered. And then they would be set for hearing, and the judge would decide if it should have been issued ex parte to begin with, which means only with one party involved, and it's on an emergency basis, or if it should be heard and argued by both sides and then decided on. So that's what happens if we file an objection. We can request relief in our answer, such as child support, custody, spousal support, any property that we think, if we need health care, if there's a name change, all of that would also be asserted in our answer. The answer has to be verified. It has to be signed by the client, swearing that it's true. And sometimes we don't do it because we don't think it. I don't know. It doesn't align with our ethics. But in some instances, an attorney might file a limited scope appearance, which means they're only going to represent the person for a certain period of time, and we're either in or we're out. We don't do that. So, but what that means is that they would be retained maybe just to answer the complaint, and then the person is going on representing themselves. And so that's just another thing that could happen. So that's what is a little bit different from representing the plaintiff and representing the defendant. The next thing that we're going to talk about today is a bit about custody. And I'm going to give you the overview today, and then tomorrow we'll really get into the meat of custody and the best interest factors that decide custody and parenting time. So basically, when we're talking about custody or a change of custody or an initial finding for where custody should be if it's not joint, and then we're going to be looking at something called an established custodial environment. But before we even get there, I think I forgot to explain, there's two different kinds of custody. There's legal custody and physical custody. Legal custody, there is a well, there's kind of a presumption now in Michigan that they'll both be joint, um, but legal custody is who has the power to make the big decisions. Um, Religion, surgery, um, experimental treatment, private school versus public school, things like that. The physical custody is where the child lives most of the time. Um, and there's really been a trend to get away from physical custody being awarded to one parent or the other, because that makes one parent a parent and one parent a visitor. And that isn't good for kids, and that's certainly not good for parents. So now, in most cases, we'll end up with joint. Um, and like I said, it's not perfect. It's not a one size fits all, and certainly there's a lot of cases that we can't do it that way and don't do it that way, but that's just the starting point, because that's where the law tells us that we should start, is because every child has a mom and a dad, and they should still have their mom and their dad if they're not husband and wife. So that being said, if you do have a joint situation, then each parent has parenting time, and they have a schedule that basically says, when they're going to have it. And we'll talk about specific schedules and the different ways that it happens tomorrow, and what those can look like. It's a matter of creativity and convenience. And some people need very rigid, some people need very loose. But the most important thing about parenting time is that the parenting time schedule is the default. There is, if parents, in reality, need to do it a different way, or it works better a different way, or then of course that's fine. If you switch the days, that's fine, as long as you agree. The problem is that you can't enforce things that aren't in orders. So, I said it's the default. So it's like the minimum. So if this is what you're not getting, then you can go to court and ask the judge to enforce it. So that's, that's basically, I think some people get really hung up on like, this is what it's supposed to be and nothing more and nothing less. And really, it's nothing less. And anything is okay. So basically, as I mentioned, when we're looking at custody, we have to look at, is there an established custodial environment? The things that the court considers when looking at that is if the child has lived predominantly with one parent instead of the other, where the child goes to school, which parent's district is that in. This assumes there's been a separation. When people are first getting divorced and custody is being decided, there isn't, they might both have a custodial environment, or or neither one of them has a custodial environment because it's not established. So that is kind of the first inquiry, and the burden of proof will depend on whether or not there's an established custodial environment. And the burden of proof is how much evidence you need to change it. And so that is just something to keep in mind. The other things that we look at, and again, as I said, this is like general day, and we'll go into more specifics about this tomorrow, are the best interest factors. The best interest factors, as I mentioned, are 13 factors that each one must be considered. No one is given greater weight than any other one, although when you hear what they are, you'll be like, well, how could they not give that more weight? And of course they can give that more weight. It just is going to be human nature. But the first factor is the love, affection, and other emotional ties existing between the parties involved and the child. and it focuses on the emotional bond um, that already exists. The emotional bond on the day that the divorce or separation is filed that exists between parents and the children. It is not the bond that occurs after a child finds out something bad about one of their parents and now they're not talking about them. That doesn't count because that would be after the filing. So it kind of protects people from the emotion that we know is going to flare up once a divorce is filed. The second one, which is B, is the capacity and disposition of the parties involved to give the child love, affection, and guidance, and to continue the education and raising of the child in his or her religion or creed, if any. And this tries to project a parent's ability to foster the emotional bond with the other parent, to foster the emotional bond with themselves in the future. It's kind of like a projective factor. And it also looks at the parent's impact on education and guidance. Who's helping the child with their homework? Who's providing any religious training or guidance? Who's going with them to church or synagogue or to the mosque? Whatever it may be. And then C is the capacity and disposition of the parties involved to provide the child with food, clothing, medical care, or other remedial care recognized and permitted under the law of the state in place of medical care and other material needs. So that's like your day to day, who can provide. And, that's more looking at, the physical things that a child needs. And, it does have the provision in there that if you're, a parent who doesn't believe in vaccinations, it can't be held against you because there's other alternatives that are accepted by the law instead of or in lieu of vaccinations. Food, clothing, it has to do with, steady income, who knows how to cook, all that stuff. D is the length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. So this is where if one parent is staying in the marital home and another parent is moving away, it should be evaluated on if the parent is staying in the marital home, if that would be better for the child for continuity or not. And there's a lot of other things that go into that decision, but that's basically what they're talking about in D. Certainly, if a child has lived in one house their entire life and they're, younger, that's probably going to be the opinion of the judge is that they should stay there and have parenting time, can be shared, but that's where they should stay in their same school and they should stay with their neighborhood friends and all that stuff. E is the permanence as a family unit of the existing or proposed custodial home. This focuses solely on the permanence of the family environment, not the acceptability of the home or child care arrangements. So this goes beyond the physical house or apartment or residence. This goes beyond who's caring for the child. This is how stable it is. And is it going to be permanent? Can it be permanent? Can the parent sustain it to be permanent? All of those things. F is the moral fitness of the parties involved. This relates to how they function as a parent, not as who is a morally superior adult. And so, who is, more patient, who has, is a better communicator with the child. Those kinds of things can go in there. This is not where because one parent or both parents, smoke pot and have criminal records. This is not where that comes in. That comes in later. G is the mental and physical health of the parties, and that disabilities do not cause a person to have a disadvantage when this factor is considered, um, as long as the person is living in mainstream society and would be able to care for a child. But mental and physical health is definitely an important factor. I will remind people that lots of bipolar individuals, lots of people with major depression, lots of people with schizophrenia, under proper care and medication are phenomenal parents. And so the mere fact that one of the parties has some sort of mental illness or defect alone is not going to be enough. You have to be able to show that it interferes with their ability to properly parent. Um, the next thing is the homeschool and community record of the child. So does the child behave when they're at home? Are they behaving when they're at school? How are they doing at school? What are they involved in the community? Where is that community? Who are the people in that community? All of those things will be evaluated in each. In I is the reasonable preference of the child. As I mentioned yesterday, the minimum age where the child can express a preference is 13. It was 14, but now I see courts creeping down to 13. But this does not automatically outweigh any other factor. It could be weighed exactly the same. It's just a matter of you know, I guess why the preference is what it is, what it's based on, and how the reasons to support the preference fit into the other factors. It's not that this factor is going to be weighed heavily, it's just that maybe the reasons cause other factors to shift as well. J is the willingness and ability of each party to facilitate and encourage a close and continuing parent-child relationship between the child and the other parent. And this is like the ding, 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 ding. This is the number one most important reason that people who should share custody don't get it, because they can't get away from their own hate. And they really need to be open-minded and remember at one time you loved this person enough to have a child. And when you decided to have a child with this person, you made a promise to that child that they'd have a mom and a dad. And that is just that's the one. That's the wind comes out of the sails right there. If clients are not, or parents aren't on board for that. For this factor, the court is not allowed to consider reasonable action taken by a parent to protect a child from sexual assault, domestic violence, or anything bad like that. Which brings us to K, which is domestic violence. And regardless whether the violence was directed against or witnessed by the child, it means they can have no knowledge of it whatsoever. If there's been domestic violence in the home or any assaultive conduct in the home, then that is where it will be counted here. The reason being that if someone is assaultive or someone has been assaulted, they are certainly not being their best selves, and their ability to parent could be impeded by those actions by other people. And then the last one is L, which is any other factor considered by the court to be relevant to a particular child custody dispute. You can't consider race at all in any of these decisions. But sometimes what we see that comes in the any other factor considered would be if someone has been in recovery for a really long time, or if someone is a substance abuser, or if someone is incarcerated and every time they get out, they're immediately incarcerated again for something else, and can't live a lawful life as a respected citizen. So those kinds of things we see come in there. Um, Also, if someone has um, a gambling problem, if someone has depleted the family assets with illegal because of illegal activity. So that is all. Those are all things that can be considered under this last one, as well as whether or not a third party is actually doing the parenting during the parent's parenting time. So let's say that parenting time is, you know, Friday to Monday, and dad, I'm sorry, I'm going to use mom. Mom works Friday to Monday from, 8 to 8. And the child's, 4 years old and wakes up at 8 and goes to sleep at 8. And grandma or the nanny or au pair is who is really taking care of the baby all day. And then mom is there at night while the baby's sleeping or the 4-year-old is sleeping. Um, is that really parenting time? No. So, the purpose of parenting time is for the parent to parent. So that is something that might be thrown in under L. So as I mentioned earlier, you can have joint legal custody and joint physical custody. There could also be third party custody, and that means that in a third person is anyone other than the child's biological or adoptive parent. So that could be a grandparent, it could be an aunt, it could be whoever. There is a parental presumption that parents are the best people to raise their children over third party, and again, the third party, if they were in a custody battle with a parent, would have to show that they, first of all, that they meet the requirements to intervene in the action to begin with, and secondly, that the best interest factors are in their favor. And so then there's other issues with custody that have to do with if people are out of state and jurisdiction and where the home state is and who can enforce the orders and things like that. The most important thing about custody that most people don't realize is that in every divorce judgment and in every custody order in Michigan, there is a provision that is required that says that the child will never be taken to a country that is not part of the Hague Convention. And basically, the reason for that is to avoid trafficking and a situation where a child has been removed and can't be removed from the United States and can't be brought back by law enforcement because the country where they are is not a participating country in the Hague Convention. Indian children are treated differently. There are the Federal Indian Child Welfare Act and the Michigan Indian Child Welfare Act. Both mandate that not only do parents have rights to parent their children, but the tribe also has rights to parent the children. So if something should happen to a parent, the tribe can step up, and the tribe definitely has an opinion in those cases. And everything is different. Burden of proof is higher. Everything is different if you have a Native American or a child involved who would fall under the Indian Child Welfare Act. Incarcerated plaintiffs or defendants obviously have the same rights as other plaintiffs and defendants and other parents. However, the procedure is different, and certainly if the person is going to be incarcerated for more than 2 years, they must have supported and or visited and or communicated during it's actually substantially supported and communicated or visited during that period of time during the 2 years, or someone else can seek to adopt the child, or someone else can seek to terminate that parental rights. The timing of the 2 years is a little complicated when it starts and when it ends. So certainly don't guess on that, you should consult an attorney. And I think we'll just end this section today with, I know we started by talking about what an established custodial environment is, and I guess that we'll finish kind of with the same thing, just by saying, I'll just read you the statutory language of what an established custodial environment is. It depends on a custodial relationship of a significant duration in which the child is provided the parental care, discipline, love, guidance, and attention appropriate to the child's age and individual needs. It is an environment in both the physical and psychological sense in which the relationship between the custodian and the child is marked by qualities of security, stability, and permanence. And so it's 100% factual determination. And it's really important to be able to advocate either that it's joint or that it's with one party or the other, and have the right facts to prevail. Don't fight a battle you can't win. And so it's fact driven, but we do deal with it anytime someone seeks to change custody. And even if in an initial custody determination, it can play a role if the parties have been separated or if there's, different circumstances. So with that, I am going to stop for today, give you some COVID information, and I'll look at my little cheat sheet. And make sure I didn't miss anything. Nope, I think we're good unless anyone has any questions. So as of today, there are 64,998 cases in Michigan, and 5,943 deaths. So it is continuing to rise. The area of the state that has the most cases at this time would be like the Muskegon, Missaukee County area, kind of the areas between Grand Rapids and Cadillac, sort of. Well, I guess in Mecosta County, like kind of in that area, Lake County, just south of there, as well as north of Grand Rapids. So we hope those people find some health and stay home and take this seriously, because it is, and we can only stay open in our current environments if everyone's doing their part, and we're not even all the way moved in yet, so it would be horrible to be having to move back so quickly. So anyway, with that, I hope that you all have a wonderful, wonderful day. 5 reasons, as always, are protective services workers are essential, the police are essential, the jails and prisons are a breeding ground for COVID-19 for many reasons that we've discussed, that being kids can get parents in trouble. And lastly, very few people, if anyone, looks good in horizontal stripes. So with that, I wish you all a beautiful, beautiful, wonderful day. We will talk about custody and parenting time tomorrow. And be well, be healthy, be home if you can. And I will see you tomorrow. Bye.